So our next speaker is exactly Varun Gowri. He is a senior economist at the research group DEC at the bank. So Varun, please.
So far this morning, we've been discussing health and priority setting under the general idea that we ought to be providing, with the question about what we ought to be providing, with a general, loosely utilitarian idea that we should be providing as much health benefits to as many people as possible. But another key question in health sector provision is not just what we provide, but who we provide it to. There are arguments that certain people, say first responders, people who've sacrificed their lives in war, others deserve priority in receiving health benefits, and some countries set up special systems for them. There are also reasonable arguments that people who are poor or excluded and who otherwise suffer in society ought to be given priority. I think this contributes to the Gordian knot that Dr. Jaime Caro mentioned. It's not just what we provide, but who we provide it to. The first is broadly utilitarian. The second is much more closely tied to a rights-based understanding. This is where things get very complicated. What I want to talk about in the few minutes I have is the question of equity. When courts get involved, who benefits? Let me say before beginning that I've been interested in this question about the impact of constitutional, social, and economic rights litigation for several years. I've done some work on the causes and consequences of this litigation, and as David mentioned, and am now involved in a couple studies of compliance with court rulings. Our department is collaborating with the Supreme Court of Costa Rica they have a tremendously interesting database on compliance with court rulings, and we're working with them to analyze some of that data, and are developing a study of compliance with tutelas in Colombia in collaboration with the Constitutional Court there. But now, what I want to talk about is equity. But before doing so, let me just say, to give you a size of the scale of the phenomenon. As we know, there are a large number of cases in Costa Rica and in Brazil. Estimates suggest that there are at least 40,000 right to health cases per year. In Colombia, there are over 400,000 tutelas per year. About 100,000 to 140,000 are on health. In Indonesia, broadening from health to also education, there's a constitutional provision that the government needs to spend 20% of its expenditures on education. The court decided to enforce that with a dramatic increase in health expenditures in Indonesia. In Hungary, the court struck down a World Bank IMF austerity package some time ago. In Egypt, the administrative courts were quite active in developing a minimum wage, particularly for truckers, and this mobilization contributed to the mobilization in the Arab Spring. The United States, of course, does not have a constitutional provision on social and economic rights, but state constitutions do. There's a lot of litigation at the state level in the United States on social welfare, on education. One could multiply examples from Nepal, Argentina, India, which I'll talk about, South Africa, which I'll talk about, Ireland, even Kenya. It's becoming a very widespread phenomenon. So much so that, and this is, if you don't like this slide, you can blame my good friend Keith Hansen, who sent this for me, that it's entered into the doctor-patient dialogue, where one doctor is saying to a patient, your infection may be antibiotic resistant, but let's see how it responds to intensive litigation. When litigation enters everywhere, what happens? There's a long-standing critique of this phenomenon that takes various forms. One critique is that courts are very weak. They have neither the sword nor the purse. They do very little. Another critique is that they shouldn't get involved in markets. They use their own set of priorities, substituting for the priorities of the democratic legislature or of markets themselves, and it leads to bad outcomes. They can't handle trade-offs. Judges sometimes look like that. Do you want that person making decisions for you? They're not equipped to handle complicated questions, is another critique. And finally, what I want to focus on is elite capture. There's a view that courts are, when they make decisions, are likely to benefit those who are better off and not the poor, whom these rights are intended to benefit. Now, thinking about this elite capture question, one can think about the life cycle of public policy litigation. To get a case in, to get a ruling, what you've got to do is, first of all, get your case on the court's docket. You've got to walk through that door. There are obstacles to access that are particularly severe for the poor. Second, there's a judicial decision. The judicial decision depends on the outlook of the judges themselves, who in many countries are recruited from certain social classes, who come from the elites and have certain kinds of affinities in their thinking. Third, the bureaucrats, the politicians, or private parties respond, and they have to implement what's going on. Now, there's another roadblock, where in the response, there are opportunities to block the decision or to massage the rulings, the implementation of the rulings in a certain direction. And finally, there's follow-up. So at each stage of this life cycle of public policy litigation, there are reasons to think that the poor will not benefit. The academic literature backs this up. Now, what our argument is going to be the following. Although a priori we might think that the poor will not benefit from litigation, not all courts and judicial systems have the same pro-poor potential. There's variation among court systems around the world. The basic point is that the more that judicial decisions have broad applicability, the more likely you see pro-poor outcomes. I'll say what broad applicability is in a minute. But basically, if you think about retail decisions and wholesale decisions, big structural decisions, wholesale versus retail, you're more likely to benefit the poor when it's a wholesale decision. And this kind of legal structure, which emphasizes wholesale decisions, turns out to be more important than getting in the door of the courts, than judicial attitudes, and even implementation capacity. So our argument is going to be that given a court decision, equity depends on the legal structure and whether the decision is made in a wholesale mode or in a retail mode. What does broad applicability look like? It can be abstract constitutional review. This is what takes place in Indonesia. In Costa Rica, there's a term, it's a control anterior de constitucionalidad, or something like that. It can also take the form in Colombia of this ruling of Estado de Cosas Inconstitucional, which they say an entire system is somehow unconstitutional. The court made a major decision in T760 to move in this direction and declared that the whole system of healthcare financing ought to be restructured. In Brazil, it can take the form of the Ministério Público, making what's called an inquérito administrativo, which begins an administrative inquiry against, say, the health secretariat to say, well, we need to figure out how you're setting priorities. It doesn't quite look right. So it can take this form of this abstract constitutional review. It can take the form of common law precedent. It can take the form of public interest litigation, which is the pattern in India, which people, NGOs, speak on behalf of others. And finally, it can take the form of regulation as a constitutional claim. Regulation is particularly important because if you think about social and economic rights litigation, there are really three kinds. There are three actors involved. For the bank staff, this might look familiar because it's taken from the WDR 2004 triangle. There are three actors in social policy provision. You have certain rulings which change the relationship between the state and recipients. These are provision. This is the I want more medication. Give me Avastin, this kind of case. There's a case that involves regulation, which is not just a claim for provision of something, but to change how the state oversees, regulates, supervises a certain area. And finally, there are cases involving the horizontal relationship between providers and service recipients. These at the bottom category are probably not as equity enhancing as the regulation cases, because to benefit from them, you have to be getting health care or education or the service to begin with. These are typically rights in health care, not rights to health care, informed consent. You have to benefit from it. You have to be able to get to a doctor to benefit from that. So we try and analyze whether this sort of study works by looking at taking data on court cases and their impact in 5 different countries: Brazil, India, Indonesia, Nigeria, South Africa, health and education. So let me just get quickly, since time is short, I'll just go to some of the data. On Brazil, this column here is the percent underprivileged. And what we try to do, looking at the secondary literature, is look at the share of people who benefit from these decisions who are from the lowest 2 income quintiles. So you take all the beneficiaries, how many are from the lowest 2 income quintiles? So if this is 40% or above, it's pro-poor. We can go into details about how this calculation was made if you're interested. In Brazil, it turns out to be 36% of the beneficiaries of these health cases are from the lowest 2 income quintiles. So it's more or less the distribution that already exists out there. It's somewhat less pro-poor than the health system itself, which has about a little bit over 40, I think 43 or 44% of beneficiaries who are from the lowest 2 income quintiles. Brazil's model is basically the retail model. Most cases involve going right to court and getting a particular medication. Now, this turns out to be not as bad for the poor as one might have thought for the following reason. As we heard earlier, there is a fair amount of dialogue between judges and the health sector officials, and it's often the case that the health sector officials actually want a ruling so that they can incorporate something into the public sector offering. So after hundreds or thousands of rulings on a certain medication, it's offered, put into the basic list. And once it's put into the basic list, it benefits not only those who have the money and resources to get into the door of the court, but anyone who goes to the SUS altogether. That's why you see this in Brazil. Let's compare that to South Africa. This is hard to see, but many of the South African cases involved AIDS. The most famous case involved the argument on the part of the Treatment Action Campaign that a reluctant Mbeki administration provide nevirapine, which prevents vertical transmission of HIV. Most of the people who have this disease are poor in South Africa, and so, and so you have overall in health 76% of the beneficiaries in the lowest two income quintiles. South African system is common law precedent. When you issue a ruling, it affects everybody. It's binding on all courts, binding on all the provinces. The wholesale model reaches more people. I'll skip Indonesia and Nigeria. In India, let me just say that, let me focus on the second case, this Delhi vehicular pollution case. This was a case in which people went to the Supreme Court of India and said that the air is dirty in Delhi. It took a long time to resolve this case, and finally, 2001, a more definitive ruling was issued, which the court said you've got to clean up the air in a variety of ways. Commercial vehicles switch to compressed natural gas. One can observe the decline in respiratory illness and asthma as a result of this ruling, and one can then look at who are the main sufferers of asthma and respiratory illness, and they tend to be more the poor than not. So 47% of the benefits went to the poor in a ruling like this. Again, a wholesale regulation case was much more tended to be pro-poor. But of course, the asthma and respiratory illness is distributed across the population, so it's not entirely pro-poor. So let me, this slide just basically says that when you try and explain the underprivileged share, which is the last column there, the best predictor is this broad applicability argument and not things like implementation capacity, even the win rate. There's a very high win rate in a country like Brazil. You know, in our sample of 4 states, 82% of the time the litigant won. But that's not related to underprivileged share because, again, those who are winning are those who can afford to get into the court. So there's some things we can't observe. We can't see who loses as a result of who wins. You know, this sort of what happens to the budget as a result and some other things. But let me just wrap up because time is short. Basically, the point I want to drive home is that when it comes to distributive effects, not all courts are the same. Judicial decisions with broad applicability are able to avoid an anti-poor bias, and the empirical investigation bears out the theory, the a priori theory, that wholesale litigation tends to be more more equitable than retail litigation. Thanks so much.